What happens when a court of law just decides to outlaw gravity?
Well, you end up with a very strange reality.
Right. Today, on our deep dive, we have this massive stack of forensic photos and, legal documents from a staggering judicial failure out of Finland. It's case 103 Sev 6624.
Yeah, and it's quite the case.
Okay, let's unpack this. We are looking at a scenario where Azona is actually convicted of throwing an industrial ladder through a doorway that is, mathematically speaking, smaller than the ladder itself.
Right, which represents a complete collapse of the beyond reasonable doubt standard. I mean, when a legal system starts prioritizing a preconceived narrative over the immutable laws of physics, it ceases to function as an arbiter of truth.
It just becomes something much more dangerous.
Exactly, becomes a tool for something else entirely.
And for you listening, I really want to stress that this isn't just some, obscure, distant legal anomaly. This is a terrifying look into how easily modern institutions can trap you in an official narrative.
A narrative that entirely abandons objective reality.
Yeah. Because if a court can just decide that solid objects can magically pass through smaller solid objects, the protections you think you have under the law are just an illusion.
They vanish, basically.
So to understand how the system broke down so spectacularly, we need to look at the timeline that triggered this whole encounter. The court's official version of events requires us to believe the defendant possesses, supernatural foresight.
Yeah, we are dealing with what we'd call the dead battery paradox.
Oh, I love that term.
Right, because the timeline of the alleged crime relies on this bizarre coincidence. The accuser in this case claimed they returned to the property at 4:50 in the morning.
Which is already a weird time.
It is. But crucially, they admitted on the record that this return was entirely spontaneous. The only reason they came back at that specific random time was because their headphones died.
Okay, wait, so a completely unplanned technical failure dictates the timeline.
Exactly.
Yet, the official narrative accepted by the court is that the defendant was standing in the pitch black, holding a heavy metal object, just lying in wait to ambush the accuser. I mean, so the court is essentially saying the defendant had a crystal ball.
That's the only way it works.
You can't systematically pre-plan an ambush for an arrival that the victim themselves didn't even know was going to happen 10 minutes prior.
No, the logistics of that simply do not exist in reality. I mean, there had been zero contact between the parties for days. To pre-plan an ambush, you need a target and an estimated time of arrival.
Right, which they didn't have.
At all. What's fascinating here is how this total lack of foreseeability, combined with the complete absence of any established motive for the defendant, points directly to a retaliatory accusation.
Or what is known in Finnish legal terms as a vastaseitos.
Yes, exactly, vastaseitos.
Walk us through the psychology of that, because it seems like a very specific, almost desperate defensive strategy.
It is. When someone initiates a physical altercation and, realizes there will be consequences, their immediate psychological defense mechanism is often to project a preemptive strike onto the victim.
Oh, so I didn't start it, they ambushed me.
Precisely. You invent an unprovoked ambush after the fact to mask your own aggression. It is a story constructed in reverse to justify the damage you caused.
Wow. And since the foundation of the story relies on this impossible, spontaneous ambush, the authorities had to figure out a way to, lock the defendant into this narrative early on.
Right. Which brings us to the procedural issues.
Yeah, because I was looking at the logs from the initial police contact, specifically this train station interrogation. What struck me is how the police essentially weaponized the environment to bypass the defendant's basic rights.
The procedural violations there are just severe. Initially, the individual being interrogated held the status of a victim, or asinomestasia in the Finnish system. They were at the police station, operating under the pretense that they were reporting a crime committed against them. But the moment they left the station and were in transit, the police made a systemic change.
They secretly flipped the individual's status from victim to suspect in their system. Right. Without telling them.
Without providing any notification whatsoever.
Which fundamentally changes the legal protections they are entitled to, like the equivalent of Miranda rights.
Utterly changes them. And then the investigator decided to conduct a formal interrogation by calling them on a mobile phone while the individual was at a noisy train station.
That's so manipulative.
By concealing the status change, the police bypassed the mandatory requirement to inform the suspect of their right to legal counsel and their right to remain silent.
Unbelievable. So the individual kept answering questions, believing they were still functioning as a victim helping the police.
Yes. Entirely unaware they were building a case against themselves.
And the environmental coercion plays a massive role there, too. I mean, if you've ever tried to have a serious conversation in a bustling transit hub with a terrible mobile connection, you know you have to shout. Your stress levels spike and your cognitive defenses just drop.
Absolutely. From a forensic and procedural standpoint, the reliability of evidence obtained under those conditions is compromised.
I would think so.
When you deprive someone of counsel through procedural deception and interrogate them in a high-stress, high-noise environment, you are engineering confusion. You're not gathering facts.
And because the police never locked down a firm timeline or established the physical boundaries of the incident during that chaotic phone call, the accuser was essentially handed a blank canvas.
You could say whatever they wanted.
Yeah, they were free to adjust their story once they realized the physical limitations of the house. It's like watching a bad screenwriter rewrite a script live on stage because the set designers didn't build enough props.
That's a great analogy. The evolution of the accuser's narrative is a textbook example of retroactive scripting. In the pretrial version, the claim was that the defendant was awakened by noise. That paints a picture of a reactive, accidental encounter.
But then it changed.
Radically. By the time the case reached the courtroom, the story had morphed. Suddenly, the defendant was waiting at the window to ambush the accuser.
You cannot be simultaneously asleep and actively standing guard at a window. The two concepts are mutually exclusive.
They are.
And the weapons they claimed were used kept changing too. First, the accuser stated the defendant threw multiple chairs at them.
Right, until the physical reality of the crime scene became inconvenient.
Oh, because they ran out of chairs?
Basically, it became apparent that there were no other chairs available in that specific area of the house to be thrown. So the official claim magically shrank down to a single chair.
Wow.
When a witness systematically alters their sequence of events and the physical objects involved just to fit the constraints of a room they just realized exist.
The reliability of evidence drops to zero.
Exactly. It ceases to be a factual account of a memory.
Which leads directly into the most baffling part of this entire deep dive. The impossible physics of the doorway.
Ah, yes. The Jakara paradox.
Because as this accuser kept adjusting their story, they eventually painted themselves into a corner that officially broke the laws of spatial reality.
The accuser's finalized narrative required the court to believe that the defendant threw a heavy industrial metal kitchen ladder, specifically a Jakara ladder.
Threw it at them through a doorway.
Yes.
For you listening, try to visualize the space. We have the forensic photos of the hallway. There is a door that is only partially open, creating a very narrow gap.
Right.
And right next to that gap, physically blocking the swing path of the door, is a massive cat tree built with thick sisal rope pillars and wide platforms.
Now consider the dimensions of a Jakara ladder.
Yeah.
It is a rigid, wide, metal-framed object. It does not compress.
Right. It's solid metal.
If you calculate the spatial geometry, which the court procedurally failed to do, by the way, the gap between the partially open door and the door jamb is just too small.
Especially since it's obstructed by the structural mass of the cat tree.
Exactly. The gap is mathematically smaller than the width of the ladder itself.
The object literally cannot pass through a space smaller than its own rigid dimensions. Unless we're throwing out solid mechanics entirely, this event could not have happened.
It's a physical impossibility.
And the proof is in the disturbance-free scene photos taken just minutes after this supposed violent high-velocity ambush.
Right. When a heavy metal object is propelled through an obstructed gap, the transfer of kinetic energy dictates that it will displace the objects in its path.
It's going to smash stuff.
It will cause structural impact damage. But in the forensic photos, the cat tree is perfectly upright.
Not a scratch on it.
There are fragile plants and paper bags resting on the floor around the door gap, completely untouched. The wooden door frame shows zero impact marks or gouges from the metal ladder.
The scene is surgically clean.
Yes, the physical environment actively contradicts the violent narrative.
And the accuser's supposed injuries contradict the weapon itself, too, which you refer to as the morphology mismatch.
Right. The morphology of an injury must align with the mechanism of trauma. The accuser claimed their injury was caused by this massive falling industrial ladder.
Which would hurt a lot.
Exactly. However, the photographic evidence presented showed two thin parallel scratches on the lateral side of the leg.
Scratches from a metal ladder.
A heavy, angular metal ladder falling onto a human limb creates crush injuries, massive hematomas, deep tissue contusions, and potential structural trauma to the bone.
Right.
It does not leave two precise little scratches on the side of a limb while leaving the surrounding tissue entirely undamaged.
The spatial math is impossible. The scene is untouched. The injury doesn't match the weapon, and yet the timeline they attach to all of this makes it even more absurd.
Oh, the timeline is fascinating.
Let's break down the 30-second myth and the phantom 4-meter brush.
According to the accuser's own rigidly established timeline, exactly 30 seconds elapsed during this encounter.
Just half a minute.
Within that half-minute window, the accuser supposedly cleared a barricade of chairs, climbed a flight of stairs, got struck by this geometrically impossible ladder, opened a door that was structurally obstructed, and was stabbed 5 times in the face with a standard household brush.
A brush that the defendant was supposedly wielding from a distance of 3.5 to 4 meters away.
Yes.
I mean, wait, a standard cleaning brush reaching a target 4 meters away? Did Inspector Gadget show up? How does a judge not simply ask someone to bring a tape measure into the courtroom?
It really is staggering.
A standard cleaning brush is roughly a meter long. Unless the defendant has the extendable arms of a cartoon character, reaching a target 4 meters away is a physical impossibility.
Accepting that sequence of events is a fatal failure of the in dubio pro reo principle.
Which is the benefit of the doubt, right?
Yes, the legal doctrine that gives the benefit of the doubt to the defendant when evidence is uncertain. But here, the evidence isn't uncertain. It is physically impossible.
Right, it's just math.
In a functional legal system, when oral testimony contradicts the fundamental laws of physics, the physical evidence must prevail. You cannot base a criminal conviction on a narrative requiring a 4-meter reach with a 1-meter object.
So if the math literally proves the event couldn't have happened this way, how does a judge look at this and hand down a conviction?
By rewriting the narrative.
Yeah, the only way to make the puzzle pieces fit is to redraw the puzzle. The court had to act as a fiction writer and literally invent the evidence.
We see profound breaches of judicial neutrality in how the final verdict was drafted.
How so?
Well, a judge's role is to evaluate the evidence presented, not to generate new context. Yet the written verdict explicitly states that the accuser entered the room angrily.
Which creates a perfect emotional context for a violent altercation, except literally no one testified to that.
No one.
Not the defendant, not the accuser, not a single witness on the stand. The court fabricated that emotional state out of thin air to inject mens rea. A guilty mind or hostile atmosphere, just to justify the narrative they were building.
It's highly inappropriate. But the manipulation of the official record goes deeper.
Oh, right. The testimony change.
Under oath, during the trial, the accuser explicitly stated regarding the flying objects, quote, "I did not see who threw the object."
That is a total unambiguous lack of visual identification. I did not see it.
But when you read the final verdict, the presiding judge altered that exact sentence to read, "He did not exactly see."
They just slipped the word exactly into the transcript.
Yes, he did.
And for you listening, think about why that is so dangerous to all of us. Appellate courts rely almost entirely on the written summaries provided by the lower courts.
Right. They aren't relitigating the whole trial.
Exactly. If a judge can casually Photoshop a testimony to create a false illusion of partial identification where there was absolutely none, well, the written record becomes worthless. And that's the only protection any citizen has against the state.
To compound that failure, the court accepted what can only be described as junk science to prop up the altered testimony.
The photo of the leg.
Yes. The prosecution presented an anonymous, low-quality photograph of a bruised shin as proof of the assault.
And there is zero context for this photo.
None.
Yeah.
There was no medical report attached to verify the cause of the bruise. There was no GPS metadata to confirm where it was taken.
Yeah.
There was no verifiable timestamp to prove when the injury occurred.
You couldn't even prove whose leg it was. It's just a random picture of a shin.
The legal system requires chain of custody and authentication for a reason. Without verifiable metadata or medical corroboration, anyone can download a picture of a bruise from the internet and present it as evidence.
That's just terrifying.
In a professional legal setting, an unauthenticated photo fails the standard of proof entirely. But the court bypassed those standard procedural safeguards to support their preconceived narrative.
We need to pause here because we are moving from bizarre bureaucratic incompetence into something much darker. There is a very real human cost to what this court did. They didn't just invent a fictional crime to secure a conviction. They used that fiction to completely shield the accuser from the documented violent crime they actually committed against the defendant.
The mechanism the court used to achieve this is called probatio diabolica.
The devil's proof.
Yes, it is the unlawful shifting of the burden of proof, requiring a party to prove a negative.
Okay, break that down for us in this context.
The accuser claimed the defendant attacked them with an outdoor street brush. Because this brush is stored outside the building and no evidence was ever provided to explain how the defendant supposedly retrieved it, the court indirectly required the defendant to prove they did not possess it.
Which is logically impossible. You cannot prove the absence of an action.
Exactly.
But the truly staggering part, the court forced the defendant to prove they didn't have the brush while completely ignoring the fact that the accuser actually admitted on the record to possessing it.
It is an established fact in the trial record.
They admitted it.
The accuser admitted to striking the defendant on the head with the heavy iron pipe handle of that exact outdoor street brush.
And we are not talking about self-defense here. The accuser initiated this attack with explicit homicidal intent.
The verbal threats were very clear.
They were swinging a solid iron pipe while literally screaming, "Aren't you dead yet? Die, die, die."
The choice of a dense metal weapon aimed at the head, combined with verbal death threats, elevates the act to premeditated, life-threatening aggression.
It's attempted murder, basically.
And unlike the phantom ladder or the 4-meter brush, there's objective forensic proof to back this up. Police photo number 3 clearly documents the severe injuries sustained by the defendant.
The flattened index finger and the massive nosebleed.
Right. The flattening of the finger is a highly specific trauma pattern. In biomechanics, it is recognized as a definitive defensive wound.
Because they threw their hands up.
Yes, it occurs when a victim instinctively raises their hands to protect their skull from a high-velocity downward strike by a heavy, rigid object, like an iron pipe.
That makes total sense.
It is the gold standard for reliable physical evidence. But the severity of this attack multiplies exponentially when you apply the eggshell skull principle.
Ah, right. For you listening, the eggshell skull principle is a fundamental legal doctrine that basically means you must take your victim as you find them.
Precisely.
If someone has a hidden vulnerability and you assault them, you are fully responsible for the catastrophic damage that results, even if a normal person wouldn't have been hurt as badly. And in this case, the defendant, the actual victim of the iron pipe attack, was highly vulnerable.
Extremely. The defendant suffers from a severe, permanent brain injury resulting from a previous skull fracture.
Oh, wow.
The medical reality of a traumatic brain injury is that the brain's compensatory mechanisms are already compromised. A subsequent high-velocity blow to the head with an iron pipe can easily cause fatal hemorrhaging or catastrophic swelling.
So it's incredibly dangerous.
Because of that extreme medical vulnerability, this wasn't just a simple assault. It was potentially lethal and should have been classified as aggravated assault with life-threatening risk.
How does a court look at a documented, admitted homicidal attack on a highly vulnerable person with a traumatic brain injury, ignore all the forensic photography proving it happened, and instead convict the victim who was fighting for their life?
It's a profound failure of justice.
I mean, it feels like we're in the Twilight Zone. The guy screaming death threats, swinging an iron pipe gets a pass, but the victim gets charged because of a magically shrinking ladder.
When a court prioritizes inconsistent oral claims over objective, measured physical reality, it ceases to function as a court of law. It becomes a tool for the aggressor.
That is chilling.
And the institutional betrayal doesn't end when the gavel comes down on that absurd verdict. We have to examine the timeline of the aftermath.
This brings us to the administrative torture of the appeals process, the 676-day limbo.
The right to a speedy trial is not a luxury. It is a fundamental human right codified in Article 6 of the European Convention on Human Rights and Section 21 of the Finnish Constitution.
Right, because justice delayed is justice denied.
These laws exist because the state recognizes that the mere existence of a criminal charge destroys a person's life. In this case, the district court handed down their flawed decision on October 30th, 2025.
And the appeal hearing isn't scheduled until October 6th, 2027. That is 22 months.
Yes.
676 days of legal paralysis over a case that mathematically disproves itself.
The mechanics of that delay are devastating. By forcing a citizen to wait 2 years to appeal a verdict based on impossible physics, the state effectively reverses the presumption of innocence.
You're guilty until proven innocent, basically.
Exactly. The individual must live with the heavy stigma of a violent assault conviction on their record. It destroys employment prospects, ruins social standing, and inflicts profound psychological harm.
It's punishment before the final verdict.
The punishment is extracted in full by the bureaucracy before the higher court ever bothers to look at the tape measure.
Imagine carrying the life-altering stigma of an assault conviction for almost 2 years, losing your livelihood and your reputation, simply because a judge refused to acknowledge that an object cannot pass through a space smaller than itself.
It's horrific.
It transforms the judicial system from a protector of civil rights into an engine of bureaucratic harm.
It forces the citizen to endure the punishment for the state's own geometric illiteracy.
Geometric illiteracy. That is the perfect phrase for this. So let's pull all of this together. What we've explored today is a masterclass in institutional betrayal.
Truly.
We tracked a timeline that demanded supernatural foresight to justify an ambush. We watched the authorities weaponize a noisy train station to strip away a citizen's right to legal counsel.
We observed the anatomy of an evolving lie, where multiple chairs shrank to one, and a vanishing weapon adapted to fit the physical constraints of a crime scene.
We saw a court abandon its neutrality to act as a novelist, fabricating emotional states and doctoring official transcripts to secure a conviction.
A very creative writing exercise.
Right. And worst of all, they used that fictional narrative to completely ignore an admitted homicidal attack with an iron pipe against a victim suffering from a severe traumatic brain injury.
And at every step, the system actively ignored the immutable laws of physics, the mathematically impossible Jakara ladder,
The surgically clean, disturbance-free crime scene.
the 4-meter phantom brush.
Yeah, Inspector Gadget's brush. So for you listening, the biggest takeaway from Case 103-76624 is that you must always trust your own critical thinking. Trust objective reality, math, and physics over an official summary.
Absolutely.
Just because a piece of paper has a judicial stamp on it does not mean it obeys the laws of gravity.
Physical evidence doesn't lie. Measurements don't adapt to fit a story. When the official narrative requires you to abandon basic geometry, you have an obligation to question the system enforcing that narrative.
Which leaves us with one final kind of terrifying thought to chew on.
Oh, what's that?
Well, if an entire modern legal system can be completely paralyzed by a single unchecked narrative involving a magically shrinking ladder and a psychic ambush, how many other closed cases sitting in the archives right now are resting on physical impossibilities that nobody bothered to measure?